Authority, signed July 31st, 2014 by Barb Roll, the Executive Director of the Department of Revenue. Today is Wednesday, December 2nd, 2015. We are in the Department of Revenue building located at 1881 Pierce Street, Lakewood, Colorado. This hearing is being held today pursuant to the Notice of Rulemaking hearing dated and published in the Colorado Register on October 30th, 2015, pertaining to Colorado Liquor Rules 1 CCR 203-2. Before we begin, if you have not already done so, please set your cell phones or other electronic devices to silent. If you do need to make or take a telephone call, I would just ask that you please step out into the hallway over here so that we can continue with the public hearing. This hearing is being conducted pursuant to Colorado Administrative Procedures Act, specifically Section 24-4-103, subsection 4 of Colorado Revised Statute. I'm going to regulate the course of this hearing pursuant to Section 24-4-103, subsection 13 of that same law. Based on the record of this hearing, I will prepare a report with recommendations on the proposed rules to the state licensing authority, who does have the final decision-making authority with respect to these proposed rules. The purpose of today's hearing is to give interested people the opportunity to submit written or oral views, comments, or data regarding the proposed rules. This is a quasi-legislative hearing, meaning that it is not adversarial. Any comments that you make can either be in support of or in opposition to the rules. The comments must be specifically addressed to the proposed rules and not to any other subject. Comments on any subjects other than the proposed rules will not be allowed. Excuse me. The rules will be considered by subject in the order provided for on the agenda, and if anyone has not received a copy of the agenda, there are copies on the table over here. The division staff will give a brief presentation on the proposed rules by subject, and then we will open the floor to public comments on those particular set of rules. If time permits, at the end of the day, once we have covered all of the proposed rules, I will then open it up to comments on any of the rules that have been presented here today. Today's hearing is scheduled to go until 4 p.m. Anybody wishing to make a comment at today's hearing, please sign in on the sign-in sheet at the table by the front door, which I now have. Okay. So if anyone wants to sign it, it is up here. A comment for each public speaker is going to be limited to 2 minutes. I will notify each speaker when their time is up, and I ask that when I do tell you that, if you can please return to your seat so that the next speaker may make their comment. Please state and spell your name so that our court reporter can key it properly, and then you may make your comment. And if you do have a comment, I'm going to ask you to sit in this chair here in front. In order to fully develop the record for the proposed rules, I may call on representatives of the division to provide comments during this hearing, or I may extend the 2-minute time limit for comments by other speakers. If you do not have the opportunity, or if you would prefer not to make an oral comment, you may submit written comments. The record is going to remain open for written comments until December 10th at 5 p.m. Written comments are submitted on Form DR 2477. You can submit those either via email to Sandra, S-A-N-D-R-A, .Lowman, L-O-W-M-A-N, @state.co.us, or by mail to the Liquor Enforcement Division at 1881 Pierce Street, Suite 108, Lakewood, Colorado 80214. Please include your name and your mailing address on any written comments so that they can appropriately be added to the record for these proposed rules.
You mentioned some letters and a number. I didn't get those. ER?
The DR form,
Okay. I'm
it's
sorry.
Form DR, David Robert, 2477.
Thank you.
Anyone who has any questions on how to submit a comment can contact the representative of the division, and they will help you with that process. All right, at this time, I'm going to ask the people seated next to me if they would please introduce themselves.
My name is Ron Cameron. I'm the Senior Director of Enforcement for the Colorado Department of Revenue.
I'm Patrick Maroney, Director of the Liquor Enforcement Division.
Linda Atkins from the Colorado Attorney General's Office.
Dynamic, the Chief of Investigations for the Liquor Enforcement Division.
Thank you. And with that, the division staff will now go ahead presenting their opening remarks and the first set of proposed rules.
Thank you. So as I understand, as far as public comment goes, we're gonna take it rule by rule and then open up the end for anything outstanding. Is that the way?
We'll go by rule series, and then we'll open it for comment.
Okay.
And then, once we've concluded, if there are any general comments on the whole rule, we can go back to the public comment period.
Okay.
So if you'd like to present, by series, 100,
Okay.
300, however you'd like to do it. Or if you'd like to do it by rule.
Yeah. Probably do it by rule. I think we'll
Okay.
just go that way.
All right, that's fine.
Okay, the first one, for the Colorado Department of Revenue Liquor Enforcement Division is requesting the following changes or new rules be added to 1 CCR 203-2. First one is Regulation 47-100. I'm not gonna read these in the entirety in the record because the document itself stands on the record. 47-100 comes to us mostly because of legislative changes this year in 2015. A new law creating a license called a distillery pub was enacted. 47-100 under definitions, changes were made to this to include distillery pub where needed as far as definitions of a manufacturer and a supplier. The words distillery pub were inserted. That's paragraphs B and paragraph F. Paragraph H is a new subsection of the rule that we request to be added that gives a definition of what's called powdered alcohol. And again, it's just a definition, it's not any regulation information, that comes later. So paragraph H is powdered alcohol. So again, 47-100 is just changing 2 paragraphs to add distillery pub to the definitions and adding powdered alcohol to definitions.
Are there any comments with regard to Regulation 47-100? All right, I see none.
The next rule or regulation is 47-302, labeled changing, altering, or modifying a licensed premises.
Patrick, I have a question.
Yes.
Sorry.
Will you please state your name for the
Yeah,
record,
my
sir?
name's Pete Mearsman, Colorado Restaurant Association.
Okay, and can you spell your last name, please?
Meersman. It's just a question, not a comment. So, I intend to speak about powdered alcohol. Most of it's in the tail end of this.
Yes.
But it does include the definition. Should I can I include that in my overall comments on this
Sure.
particular definition, 47-100H?
If you have anything with specifically regard to the definition, go ahead and make those comments now. Otherwise, if it's regarding to the regulation overall, let's wait until we get to that section.
I understand where Mr. Mearsman is coming from. A definition, it's just that definition doesn't include the regulation yet. I think if you just talk about the definition part, it might be difficult, I don't know. Because I'd rather wait till the rest of it come in to speak to the overall general concern.
Sure.
Not necessarily just, because right now you can only speak about the definition.
Okay, so Pete Mearsman, Colorado Restaurant Association. And all I want to say about the definition is I believe that since this is saying that it is going to be regulated as a spirituous liquor, part of my comments later on will suggest that it be regulated separate from spirituous liquors. Okay, it'll be registered, it should be regulated as powdered alcohol versus liquid alcohol. And that's in my comments later on during this hearing. So
Okay.
so the definition you may wish to consider changing it based on what I say,
Okay.
or may not. Thanks.
Any additional comments with regard to Regulation 47-100? All right.
Okay, 47-302, as mentioned before, changing, altering, or modifying the licensed premises. This is a request to change paragraph D to add a limited winery to the to paragraph D to where the regulation of modifying a licensed premises applies currently to just a manufacturer. when this rule was changed 2 to 3 years ago in paragraph D before, a limited winery was inadvertently left off. So a limited winery did not have the same abilities as a manufacturer winery, so we wanted to add a limited winery into this section to be able to add the ability for a limited winery to have modifications done in accordance with the rule, just like a manufacturer winery.
Any comments with regard to regulation 47-302? All right, I see none. Mr. Maroney?
Regulation 47-303. Paragraph F is requested to be added to the rule called license renewal. Earlier in 2015, the legislature and the governor signed a law that created a reissue license. This is where a license could be reissued after being expired more than 90 days, not less than 180 days. So this rule, paragraph F, was added to reflect the law that was added this year. And paragraph G was changed to the from 90 to 180 days as far as a reissue license is concerned.
Any public comment regarding regulation 47-303? I see none. Mr. Maroney?
Thank you. Regulation 47-304, transfer of ownership and changes in licensed entity is the title. In paragraph E, it was discovered that the rule language and the verbiage of the rule was different than as Colorado Revised Statute. So all this did was make the rule mirror Colorado Revised Statutes when it discusses the operation of law. So this is more of a grammatical change than anything else.
Are there any public comments with regard to regulation 37-304? I see none. Mr. Maroney?
Regulation 47-316, titled Advertising Practices. This rule change comes to us as a part of the workshop and working groups we had in the spring and summer of 2015, where it was requested that we give a little bit more definition to what social media is, to bring it in line with current practices in the electronic world we see today. So we added words to paragraph C 1, 2, and 3 to make it a little bit more clear on what it was defined as media for suppliers and retailers, to include the internet, device applications, things like Facebook and blogs and so forth. So again, this is more of to make the rule more current.
Are there any public comment with regard to regulation 37-316? I see none. Mr. Maroney?
Next one is regulation 47-322, titled Unfair Trade Practices and Competition. Again, earlier this year in 2015, a law was passed to create a new bill or a new license type called a distillery pub. A distillery pub is a retail type of license that's able to sell all three kind of alcohols on premises, and also sell and also make distilled products and sell them for on premise and off premises. In the definitions of 47-322, a distillery pub was added to the definition of being a supplier. It was also added to be a definition of a retailer. It's not obvious because the words doesn't show up in the retailer section. I'm going to read these verbatim though, so I can help everyone understand what we did. So the definition of retailer means those persons licensed pursuant to sections 1247, 401, H through T, and then I added and V. V is where the distillery pub is found as far as the license type. So the word distillery pub does not show. It is signified by just the paragraph V, as in Victor. We also added it to the definition of a wholesaler. And under paragraph A5C of 47-322, we added distillery pub to be included in that section as a retail license. in paragraph F of 47-322, titled Consignment, Sales, and Lawful Product Returns. This change came out of the working groups we had this spring and summer to bring clarity of two situations. One is when a malt liquor or fermented malt beverage product is out of freshness, which means that it's past its expiration date. And as a seasonal product, how is that handled when it comes to returns? This rule clarifies and does two things. Number one, it gives a definition of what out of freshness is, which was not there before. And then it gives guidance on how a seasonal product that's out of freshness is handled.
Are there any public comment with regard to Regulation 47-322? Okay, I see none. Mr. Maroney?
Regulation 47-323, titled Lawful Extension of Credit. Again, this comes to us because of the new distillery pub law. We added, under the definition under paragraph 2 of this regulation, the distillery pub as a retailer. Again, it was added by including the paragraph V as under the retailer definition.
Are there any public comments with regard to Regulation 47-323? I see none. Mr. Maroney?
Regulation 47-400, titled Licensed Breweries. Earlier this year, a law was passed creating local oversight for sales rooms of malt liquor in wholesale sales rooms. This rule is being changed to be in accordance with that law of what a wholesale beer sales room looks like, as far as how they can sell. And I'm going to read it just for the record. All brewers who are licensed pursuant to 1247-402 CRS and to sell or manufacture product directly to consumers for the consumption of the product for either on-premises or off-premises consumption must also obtain a wholesale license pursuant to 12-47-406 CRS. So this just made it clear that the sales room is for on-premises or off-premises consumption.
Are there any comments with regard to Regulation 47-400? I see none. Mr. Maroney?
Well, thank you. Regulation 47-408, purchases by retailers. This was just a cleanup to where in earlier revisions of this rule, paragraph sequence was not correct, where we went from A to C, we skipped to B. So we changed, all we're doing for this change is to make the correct paragraphs to go A, B, C, and D.
Are there any public comments with regard to Regulation 47-408? I see none. Mr. Maroney?
47-412, wholesale warehouse or branch houses. This again came to us because of the new law with local oversight of malt liquor sales rooms. And this was to clarify the division's position that in order for a malt liquor establishment to have a sales room, it has to be within the wholesale licensed premises. So this did two things. It clarified a position that the division had as far as the wholesale licensed premises must be where the sales room is located, and it helped clarify that that's the wholesale license is where in law the sales room gets its guidance.
Are there any public comment with regard to Regulation 47-412? I see none. Mr. Maroney?
Regulation 47-418, titled Restaurants. This was cleanup language again. Previously, this rule really talks about the standards that a hotel and a restaurant must keep within cleanliness. In the current version right now calls the entity that regulates this the State Board of Health. When we changed that to the correct department, which is the Colorado Department of Public Health and Environment. It's more of a language change. We also made one small change to where we struck the need for the restaurants to be in full compliance with requirements in order to keep a liquor license. They have to have a valid food service license. That did not change, but this rule came about us for us to be allowing restaurants that may have a minor infraction still have a liquor license as long as their retail food service license was intact. That was in paragraph D. Paragraph E is in Edward. Again, we just it was minor. It was a cleanup in language to get rid of the word regulation and we replaced it with section.
Are there any public comments with regard to Regulation 47-418? I see none. Mr. Maroney?
Thank you. Regulation 47-424, engaging in business. Two changes were made, or additions actually in this case, to language. Again, because of the distillery pub bill that created a new distillery pub license type, it was added to this section. And during the review of this to add distillery pub, we also realized that vintners restaurants was left out as well. So I'll read it as requested. No person, firm, corporation, or association shall engage in the business of selling, offering to sell, using or soliciting orders for alcoholic beverages from any Colorado licensed wholesaler or retailer, except and unless said person, firm, corporation, or association shall be duly licensed brew pub, distillery pub, vintner's restaurant, manufacturer, wholesaler, or importer as required by the laws of the state of Colorado.
Are there any public comments with regard to Regulation 47-424? I see none. Mr. Maroney?
Regulation 47-426, titled Delivery of Alcohol Beverages. This requested addition to the rule comes from the division in providing clarity in what type of business can deliver alcohol. Within the law and current regulations, there's a limited number of license types that can deliver alcohol to personal consumers. The current rule says that you may not have a delivery-only business. We found businesses out there that really needed guidance of what that meant. That mean being open 1 hour, 2 hours a day, being open just 1 hour a month. Did that incorporate what a delivery-only business is? So what we did is we provided minimum standards for if a license type that can deliver, what the minimum standards could be in order for them to deliver. And it added 3 things. You must be open to the public a minimum of 3 days a week, and open the public a minimum of 5 hours each day that the business is open, and have signage viewable from a public road. We felt that this is a minimum standard for a company who has a retail license that can deliver in order to be to deliver.
Are there any public comments with regard to Regulation 47-426? I see none. Mr. Maroney?
Regulation 47-428, titled Manufacturer Sales Rooms. Earlier in 2015, a law was passed providing local licensing authority, not review of licenses that were able to have manufacturer sales rooms. This included distilleries, wineries, limited wineries, and wholesale malt liquor sales rooms. The current rule as it is, paragraph A through E, is requested to be fully stricken, and we start over again and go paragraphs A through L. And what these paragraphs A through L requested to be added were vetted through the liquor industry working groups and the rulemaking working groups. The industry from all facets, from manufacturers, wholesalers, and retailers, and the division came together to craft these rules. And what it does is it gives definition of the time frame that licenses have to be requested for sales rooms, the man of time, and that they have to respond from local licensing authority. One specific mandate from the legislature is that by rule, we had to designate how long the local licensing authority had to get back to the state licensing authority, whether or not they want a sales room in their community or not. And we, as a division, are requesting that amount of days be 10. I'm sorry, 8. In paragraph F of the proposed rule, it says, for a proposed sales room operating not more than 3 consecutive days, the local licensing authority must submit its response to the state licensing authority within 8 business days from the date of application to the state licensing authority. That was one mandate in the law that they said we had to designate by rule. The rest of paragraph A through L gives guidance to the applicant and to the local licensing authority on what they must do in order to have a sales room application processed.
Are there any public comments with regard to Regulation 47-428? I see none. Mr. Maroney?
Thank you. Regulation 47-500, titled Excise Tax Audits. Paragraphs A and B and discusses excise tax, and because of the distillery pub bill created a new license type called the distillery pub, we had to make reference to it as far as their excise tax responsibility. So we added distillery pub to both paragraph A and B accordingly.
Are there any public comments with regard to Regulation 47-500? I see none. Mr. Maroney?
Regulation 47-902, titled Sanitary Requirements. Just like we did earlier under the rule, 47-418. 47-902 was again cleanup language to change the wording of the State Board of Health to the Colorado Department of Health and Public Environment, or Public Health and Environment. Again, this language just was made to bring it up to the correct terminology as the department is named now. This also takes away the mandate for full compliance and requirements of the food service establishments have to be in effect in order to have a liquor license. As long as they have a valid restaurant or a valid food service license, they can still have a liquor license.
Are there any public comments with regard to Regulation 47-902? I see none. Mr. Maroney?
Okay, Regulation 47-904. Labeled or titled Product Labeling, Substitution, Sampling, and Analysis. In paragraph C, this comes to us because of the malt liquor sales room law that was added this year that gave the ability of a malt liquor manufacturer sales room with an on-site, or a malt liquor whole manufacturer with an on-site wholesale sales room have the ability to refill like growlers and other containers for their patrons. This rule helped make that clear, that they were able to do that as a wholesale in a sales room. Paragraph F came to us because the division found that the current reading of this rule in paragraph F creates a situation where manufacturers in Colorado are in a situation where they're stuck between a rock and a hard place. The way the current rule reads now is you have to register all products made in Colorado. All alcohol products must be registered with the division. But the current rule says that they also have to obtain a certification of label approval by the federal government or a certificate of exemption prior to registration. Due to the changes in the federal rules and guidelines, there are several situations where licensees are not able to get either a COLA, which is a certification of label approval, or a certificate of exemption. So the way the current rule reads now is you must register your product after you get one of these two things from the federal government. And one of those two things were not able to be obtained by the federal government, so they were sort of like, well, what do we do? So we're adding language here to make it more of a, if required by the federal government to do label approval, you have to provide that. So this makes it easier for the manufacturers in Colorado to register their products with the division without being out of